So welcome to continuation of our company law class. So this morning we would like to first discuss names of companies, and after that we will discuss the constitution of the company. So just before we do that, as I tell you all the time, you must have your law by your side. So make sure that you've opened your law. So get your law by your side and open section 21. We have already met the name of a company when we were discussing the mechanics of incorporation or the registration of the company. But it is important for us to take a step back and look at it as a sub-theme on its own. So, particularly so, there'll be some important changes which have been made to our law following the repeal of Act 179 by Act 992 in 2019. And that provides another reason for us to pay attention to this. And from the point of view of practice, we want to avoid making very basic mistakes when it comes to matters relating to name of the company. So first, we note that unlike the old law, that is the repeal at 179, where the name of the company was a very simple in the sense that if the company was limited by shares, all that you had to do was to have LTD or limited at the end of it. And that was it. If it was not limited by shares, you didn't have to write anything. Of course, that has its problems. The problem being that from our very initial classes of company law, we came to appreciate that there are different types of companies, public companies on one hand and private companies on the other. But under the old law, if you look at section 15 of the repealed Act 179, as I indicated, apart from the word limited being used as the ending of the name of company limited by shares, we didn't have any other qualifier. And that did not help much, particularly so. You could not just look at limited and say whether this is a private company or it's a public company. And that was quite worrying. In the same vein, we also have companies which are limited by guarantee. And we also need to know those ones by looking at the name of the company. But under the old law, if you look at the name of the company, you could not, if it was company limited by guarantee, by looking at the name of the company, you could not get the clear information as to whether it was really limited by guarantee, unless you want to look at the certificate or the regulations. So that was not very helpful enough. And again, we also have uh, unlimited companies, which may be private or public. And that one too, you couldn't even distinguish that from company limited by guarantee. And that was quite worrying. And that is why the lawmaker decided to make the changes which we have in our new law, Companies Act 2019, Act 992, particularly at section 21. So that is the basis for having that. So let us keep that in mind. So I would like somebody to be the class reader and read section 21 for us. Who will read for us? Just put up your hand. Your mic will be released. Okay, Justice. Okay.
Yeah, section 21, subsection 1. The last words of the name of a private company limited by shares shall be limited company, or the abbreviation LTD. B, public company limited by shares shall be public limited company, or the abbreviation PLC. C, company limited by guarantee shall be limited by guarantee, or the abbreviation LBG. And D, private company unlimited by shares shall be private unlimited company, or the abbreviation PRUC. E, public company unlimited by shares shall be public unlimited company, or the abbreviation PUC.
Right. Thank you. Yeah, so if you look at, I would like to continue, but if you look at section 21.1, as he has read for us, those designations that have been provided are very helpful in a number of ways. It tells us right away whether the company is limited by shares or not. If it is limited by shares, is it a private company or public company? If it's a private company limited by shares, we simply have the LTD or limited. Simplicity, we know that this is a private company. If it is a public company limited by shares, we have public company limited or PLC. So if you see PLC at the end of the name of a company, that is telling us that it is a public company limited by shares. But as I indicated, if you look at the repeal at 179, section 15 thereof, we didn't have anything there similar to this. All that we had under section 15, one of the repeal at 179 was as follows, quote, the last word of the name of a company limited by shares shall be limited. That is it. Meanwhile, if you went back to look at the types of companies in terms of section 9, in terms of section 9 of the repeal at 179, we are told we have public company limited by shares, private company limited by shares. So why is it that when it comes to writing the name of the company, you say that if it is a company limited by shares, then have limited at the end of the day, at the end of the name. And that does not actually help us to get the distinction. And I think that on that score, the new provisions we have here, I think provides better clarity than what used to be the case. And that is good. And again, as I said, limited by guarantee. If you have, let's say, Kuntanasi Youth Association, or you have friends of ancient history, Ghana. Let's suppose that these are commonly limited by guarantee. Now, if you look at it, nothing actually tells you right away whether it's a commonly limited by guarantee. And the worrying thing is that we may also have other unincorporated. We have other unincorporated associations and things like that having the same name. So by just looking at the name, we are not able to tell whether this is a company incorporated as limited by guarantee or not. And that is why having the LBG for short at the end of a company limited by guarantee now, I think, is a very helpful new addition to the law. And again, it was even more worrying, especially how to draw the distinction between a company limited by guarantee and unlimited company. Unlimited company, nothing was written at the end of it. And then again, company limited by guarantee, nothing was written. So if you look at the name, maybe football lovers, no, club. And then we have swimming friends club. It may well be that swimming friends club is a limited, unlimited company, okay? And then the other one is the football one is a company limited by guarantee. But just by looking at the name, under the old regime, you could not get the distinction. Now, under the new law, in terms of section 21, 1, C, D, E, we get the clarity as whether it is limited by guarantee or not limited by guarantee. So I think that is one thing that we need to pay attention. Now let's move on to the subsection 2. Subsection 2. Okay, so we are told that a company shall not be registered by a name which, in the opinion of the registrar, is misleading. Is misleading or undesirable. So if you want to have a name for your company, you have all the freedom to do that. But at the end of the day, the Registrar of Companies has the statutory mandate to make a determination as to whether the name that you have proposed is desirable or not misleading. And interestingly, if you look at the case of R against Registrar of Companies, ex parte, Attorney General, it's an English case. We have actually an mentioned aspect of it before when we were discussing the processes or the mechanics of incorporation. And in that case, for example, the Registrar of Companies rejected the use of the names Prostitute Limited and Hookers Limited because the view was that that was undesirable. And of course, it's also undermined public policy. As you know, in contracts, even when it comes to contract which promotes the public policy, that will not be enforced. Remember the case of Pierce and Brooks. So how much more if you want to have a company and the name is going to be Prostitute or Hookers Limited. So in the R against Registrar of Companies, ex parte Attorney General, it's an English case decided in 1991. The Attorney General applied to cancel the incorporation and registration of the company, which had the name Lindy St. Clair, into bracket Personal Services Limited, by the Registrar of Companies. Now, there was a previous attempt to register the company as Prostitute Limited, which was refused by the Registrar of Companies. Subsequently, the company attempted to register with the proposed name Hookers Limited, and this was also rejected by the registrar. And the company was subsequently registered by the registrar under the name Lindy St. Clair, into bracket Personal Services Limited. And then the object of the company was to carry on the business of prostitution. The only director of the company was Miss Sinclair, who described herself specifically as a prostitute in the documents submitted to the Register of Companies. Now, in seeking to quash the registration of the company, the court held that the company was formed for the purpose of carrying on a trade that involved illegal contracts, because the purpose is a sexually immoral purpose and as such against public policy. Yeah, so let's keep that in mind. So where the name is misleading, certainly it will not be accepted. A similar thing happened in the case of R against Registrar of Companies, ex parte Bowen. You've also made that case before, ex parte Bowen. And in that case, an application was made to the Registrar of Companies. I'm talking about the UK Register of Companies, to register the memorandum and articles of association of a proposed company under the English Companies Act of 1908. The name of the company, as we met when we were discussing the mechanics of incorporation earlier on in this course, the name of the company was the United Dental Service Limited. And the objects of the company stated in the memorandum included to carry on the practice, profession, or business of practitioners in dentistry in all its branches. So the memorandum articles were signed by 7 persons who are all members of the society called the Incorporated Dental Society Limited. And then the members of which are all unregistered practitioners in the dentistry. So look at it. We have a dentistry company, and then the members are not licensed or registered dentistry practitioners. So the Registrar of Companies refused to register the company unless the memorandum provided that the work of the company should be undertaken only by means of qualified dental practitioners. That is, dental practitioners registered under the then Dentist Act of 1878. Or the title was amended so as not to include the word dental, dentist, or any similar or equivalent word. So eventually, there was an action for the registrar to show cause why mandamus should not be granted to compel him to register the memorandum and articles of association delivered to him. So the Registrar of Companies got the application and probably put it somewhere because it wasn't in agreement. And the applicant, after waiting for some time, having thought that, well, we've made the demand for performance of a statutory duty as required by the law mandamus, and you are not doing it. So we are dragging you to court for the court to order you to do the needful. So this is what brought the instant matter before the court. So when the mandamus application came before the court held that the use of the proposed name, that is the United Dental Service Limited, was unlawful. And the presiding judge, the Chief Justice of the State, Lord Reading, rendered himself as follows, quote, "In my opinion, the question turns in the main, although not entirely, in view of the arguments addressed to us, upon whether the use of these words, the United Dental Service, would amount to an offense under the Dentist Act 1878. In other words, whether the use of those words is a description, implying that the persons who are intending to practice under the name are persons specifically qualified to practice dentistry. That is, whether those words mean that the person who are ready to perform that service are, or may be persons who hold a license, diploma, degree, or whatever the term may be, which is used, implying that such persons are entitled to be registered under the Act for the reason that they hold such license. So, in other words, the court was just trying to say that the registrar was actually right not to register them, because if you look at the name of which have been proposed to be registered, it will create the impression that the company actually was authorized to practice or run dentistry. And we have qualified people to do that. But that's the information available indicated. The members were actually not licensed or registered dentists. Just like, let's say that somebody was to register a chambers, okay? You go and register a chambers. Meanwhile, you are not a lawyer. And you are allowed to. You set up, people will bring services thinking that you are qualified to practice law, when in fact you are not qualified. So a similar thing happened in this particular ex parte Bowen. Now, with respect to this misleading or undesirable, it is important for us to also remember a relevant law. There's a legislation we call the Protection Against Unfair Competition Act 2000, Act 589. So we have a legislation which we enacted in Ghana as far back as 2000, and the title is Protection Against Unfair Competition Act 2000 at 589. And this legislation, among other things, particularly Section 1, it has the sectional heading, causing confusion with respect to another's enterprise or activities. Now, just before I read that, you notice that names can actually create a misleading impression for users of a service or for consumers. And that is why the law has given the Registrar of Companies to exercise proper control over proposed names to be registered. So if you look at this at 589, that is the Protection Against Unfair Competition Act 2000 at 589, Section 1A provides that any act or practice In the course of industrial or commercial activities, that causes or is likely to cause confusion with respect to another person's enterprise or its activities, in particular, the products or services offered by that enterprise, constitutes an act of unfair competition. B. Confusion may, in particular, be caused with respect to a trademark, whether registered or not, B. a trade name, C. a business identifier other than a trademark or trade name, D. the presentation of a product or service, or C. a celebrity or well-known fictional character. So these are all matters which can cause confusion regarding a person's enterprise. Now, Section 2 also provides, and I quote, the sectional heading for Section 2 is damaging another person's goodwill or reputation. So any act or practice in the course of industrial or commercial activities that damage or is likely to damage the goodwill or reputation of another person's enterprise or its activities constitute an act of unfair competition, whether or not the act or practice causes confusion. So damaging another person's goodwill or reputation may in particular result from the dilution of the goodwill or reputation attached to A. trademark, whether registered or not, B. a trade name, C. a business identifier other than a trademark or trade name, D. the appearance of a product, E. presentation of a product or service, or F. a celebrity or a well-known financier, a fictional character. And then Section 3 finally will tell us that any act or practice in the course of industrial or commercial activities that misleads or is likely to mislead the public with respect to an enterprise or its activities, in particular, the products or services offered by that enterprise constitute an act of unfair competition. So this time we're not talking about just confusion, but also misleading the public. So Section 3.2 will tell us what amounts to misleading. Misleading may arise out of advertising or promotion and may, in particular, occur with respect to A. the manufacturing process of a product, B. the suitability of a product or service for a particular purpose, C. quality or quantity or other characteristics of a product or service, D. geographical origin of a product or service, E. the condition on which a product or service is offered or provided, or F. the price of a product or service or the manner in which the price is calculated. So the takeaway is that when you are choosing a name of a company, you must be mindful of this protection against unfair competition so that the name you choose does not cause or likely cause confusion with another company or mislead or likely to mislead the public with respect to another company. And the legislation at 589 has given us the various possibilities of permutations in which you can have a name that will mislead or likely to mislead or confuse other people. So let's keep that in mind. Yes, Chris.
Hello, my lord. Good morning, please.
Morning.
Thank you. I want to find out the relationship between this very provision and the thought of passing off.
Okay.
Thank you.
All right, good. Yeah, the thought of passing off is very much embedded in most of the things that have been codified and at 589, because the thought of passing off is letting it appear that as if no particular like no business or product is what you are presenting to the public, and this may be either the name that you have chosen or how you have presented the name, or how you present it to the public. And that very much coincides with what uh, the Protection Against Unfair Competition Act is telling us, the various permutations in which you are likely to cause confusion or mislead, because that is what the thought of passing off also protects. People have a business reputation, goodwill. The thought protects that interest, that should not be whittled away, but other unscrupulous people who may want to indulge in some other strategies to let it appear to the public that it is that authentic or that original product or business which is being communicated or presented to them. So on that score, it's very much relevant. It's very much relevant. Whereas the thought of passing off is a common law concept, now it's elevated to a statutory pedestal or statutory status. Is based upon the statutes. Yeah, so let's take section 21.4. No, but before 21.4, the 21.3, it's important to remember that if you are going to present a name for registration, the name should not be the name of a company which has been dissolved within preceding 5 years. So if there was a company which was dissolved, let's say 4 years, okay, and let's say the company was called ABZ Limited, because 5 years have not elapsed, you will not be allowed to use that. Of course, for various policy reasons, either they may want to re-register the company with the same name, but even if they want to re-register the company with the same name, it will still not be permitted, because we want to avoid confusing whatever led to the dissolution of the company, whether it was compulsory liquidation or members voluntary winding up. We don't want confusion in the minds of the public, so there should be 5 years, if you like, a cooling period for that particular name. After 5 years, you may use that name if the Registrar of Companies so agrees. And of course, that provision also dovetails very well into a similar provision we'll come to when it comes to disqualification of a director. Like where you were a director of a company, for example, which has been dissolved, or it has become like bankrupt or insolvent, as it were. 5 years will have to elapse before you will be qualified to be appointed director. And of course, remember the case of Derek Edudemfi against the Attorney General and so on, in which he sought to challenge the constitutionality of provisions which were just carried over from the repealed Act 179 to Act 992, saying, among other things, that if you have been charged with a crime involving dishonesty or fraud, even if you have not been convicted, you are disqualified. So if you look at the new section 177, for example, those provisions were there, and in section 173, and the court was of the view that because of the presumption of innocence under Article 19, you cannot say there is somebody has been charged with a particular offense concerning formation of a company. It doesn't matter that the person has not been convicted. The person is disqualified. That is actually undermining the letter and spirit of the Constitution. That even if you are charged with a crime, you are presumed to be innocent. And for that matter, if you look at section 173, we'll discuss that later when we're talking about the qualifications of a director. Section 173(2), for example, says that. No, so 173(1), a person who is prohibited from being a director or promoter of or being concerned or taking part in the management of a company as a result of an order made under Section 177, so long as the order remains in force, unless leave to act as director has been granted by the court in accordance with that section, that you cannot be a director. So if you go to the Section 177, we are told, among other things, that particularly, if we look at the 177 1, no, no, sorry, 177 subsection 2, okay? Among other things, we'll be told that without limiting subsection 1, a person is automatically disqualified for appointment as a director or to act as a director of a company for a period of 5 years if that person has been convicted, be convicted within the last 5 years of an offense involving fraud or dishonesty or relating to formation running of a company. B, has been a director or senior executive of a company that has become insolvent within the last 5 years on account of or partly as a result of culpable activity of that director. So this somehow provide a rationale for also saying that where a company has been dissolved, if you want to use the name of that company, you need to wait for what? 5 years to elapse before you may submit that name for registration by the Registrar of Companies. Otherwise, you'll be sinning against Section 21(3) of Act 992. Another point to note is also that the company may elect to change its name by passing a special resolution. And then you have to submit it to the Registrar of Companies for approval. So it's permissible for the company to change its name. But then if it's going to change its name, the proposed name will still have to meet the test we'll be discussing. That it should not be undesirable and should not be misleading. And mind you, it is a special resolution which will have to be passed. Special resolution is different from ordinary resolution. Later on, we'll be discussing law of meetings. And you notice that in the case of special resolution, the notice convening the meeting should actually announce it, that this particular resolution will be passed. And again, at the meeting, it should secure favorable endorsement of 75% of those who are eligible to vote present at the meeting before a special resolution will be considered to have been passed. And once it is passed, you need to submit it to the Registrar of Companies for approval. And then it is approval by the Registrar of Companies that the registrar will have to make sure that it is not misleading or it is not undesirable, as we'll be discussing. Now, it may well happen that either through inadvertence or it just escaped everyone. A company on first registration or on registration of a new name is registered, which in the opinion of the registrar is misleading or undesirable. The company shall change the name of the company with approval of the registrar. So the registrar will give 6 months directive. That within 6 months, you must change this name because from my assessment, this name is misleading or this name is undesirable. In fact, if the Register of Companies is to really keep itself busy, it can be doing audit of names of companies. So as we find out, some time ago, the Registrar General made me do some work for them under this new legislation, but I don't know whether they were able to do anything with it to make it more concrete, or they just put it in their cupboard. The idea was to generate lists of certain words which should not be used in the name of a company. And if those words were being used in the name of a company, because of the special context which those words suggest, certain approvals will have to be obtained from the relevant regulators or public bodies. So, for example, we're going to say that if somebody, for example, put, let's say, education service, okay, in the name, you want to register maybe a company, and you want to call it maybe like the Bantima Education Service for privileged students. The phrase education service may appear to suggest that it is actually Ghana Education Service which is doing that. But this may not be so. It may be purely private initiative. Or if someone wants to put the word hospital, the word clinic, or the word legal services and things like that in the name of a company, then you must bring other evidence showing that you have obtained the requisite approval or license from the relevant regulatory body before you be allowed to have such a name registered. Or just like if someone wants to put the word bank, okay, in the name of a company, certainly you must be licensed by the regulator, Bank of Ghana, before you can include the word bank in your name. So if the Registrar of Companies, for example, is interested, it could be doing an audit of the registered companies in this database vis-a-vis their constitutional documents and so on, and make a determination as whether he would like to invoke his power under section 21, 5 and 2, and give them directive that they should change the name within 6 months. Now, where the registrar is of the opinion that by reason of the change in the objects, that is what the company is set up to do, or the nature of the business carried on by the company, the name under which the company is registered is misleading or undesirable, the registrar may direct the company to change the name, and the company shall change that name within 6 weeks of the direction, unless within that time the company has lodged an appeal to the court against the direction. So the court here refers to like the High Court. If you disagree with the decision of the registrar, you don't go to the Circuit Court, you go to the High Court. You don't go to Court of Appeal or Supreme Court, go to the High Court before later on, if you want to appeal again, you can appeal. Now, the 21.7 is telling us something different. It is permissible for a company to change the activities which it registered to be doing. Now, oftentimes, there is a healthy relationship between the nature of objects or the activities that you want to be doing as a company and the name by which you want to be referred by. So therefore, where for whatever reason you decided to change what you originally set out to be doing, you are doing something else, it may warrant consequential modification or change of your name so as to let your name align with your core activities. Otherwise, you may be misleading or confusing the public, in which case it will be a proper scenario for the Registrar of Companies to intervene and direct you to change your name. And when you are so directed, you must comply within 6 weeks. Unless maybe if you disagree with the registrar, then you appeal. Yeah, so if you go to the court can, if the court agrees with you that the registrar is making a wrong judgment as to whether the name of your company is misleading or confusing, the court can cancel the direction of the registrar. Or if the court agrees with the registrar, the court will confirm it, in which case you have to change your name within 6 weeks of the confirmation. But there's an interesting development here. Maybe you want to buy more time, okay? Because originally, the registrar gives you 6 weeks to comply. And you want a bit more time. Maybe a smart lawyer would, for example, wait just 2 days to the expiry of the 6 weeks within which the registrar directive is supposed to comply with. Then he will file an application or an appeal in the High Court against the directive of the registrar. And that may also take a while before the court will give a definitive hearing and pronouncement. And if the court should even agree with the registrar, the court may probably, based upon the wording of 21.8, you have 6 weeks from the date of the confirmation. From the date of the confirmation. So instead of the first 6 weeks, you could end up having 6 plus 6, 12 weeks to comply with the directive. But where the time elapses and you haven't complied, the registrar has the power to compulsorily change the name of the company. And the veil will also be lifted to find out those human beings in charge of the company refusing to let the company carry out the directive of the registrar. And the directors responsible who are cognizant of the default will have to be punished by being fined by administrative penalties. So where the change has actually occurred, the company is supposed to record the new name in its processes, and a new certificate of incorporation, which indicates the change of name, will have to be issued so that the new name will appear on the certificate of incorporation. And now the Registrar of Companies is also supposed to have its special equivalent or gazette called the Companies Bulletin. So the new name will have to be published in the Companies Bulletin, and then the website of the Registrar of Companies will also have to carry that, and will have to be a single publication in the daily newspaper in the district in which the registered office of the particular company is situated. And where there's a certificate or advertisement in the company's bulletin, it is considered conclusive evidence of the change to which the change of name relates. So let us keep that in mind. But the other point to note is that the mere fact that there has been a change in the name of the company does not mean that it's going to affect the liabilities and accrued rights or affect any ongoing legal proceedings by or against the company. So if there was a proceedings involving the company and there has been a change in the name, it will continue, just like when we had these mergers and so on, an acquisition. Barclays Bank of Ghana became Absa Bank. So if there was a case going on, it will not affect the change of name, will not affect those cases or those legal proceedings. Now, just to let you know that the lawmaker is serious, that every company should follow the new regime of writing the name of the company under Section 21(1). That is, if you are limited by shares, you have the limited at the end as a private company. If you are publicly limited by shares, you have the PLC and so on. Now, the lawmaker gave a transition period of 6 months. So, from the date that Act 992 came into effect, companies had 6 months to fall in line with the new regime. Now, what about where there has been a mistake in writing the name of the company? When you have like a mistake in writing the name of the company, what happens? Where there's been a mistake in writing the name of the company. And then we used to have a section 121. What's my law? Section 121 of at 17. Now let's look at the equivalent. Yeah, so equivalent of section 121 of at 17 now is section 125 of this at 992. when you have the table of a comparison at the beginning of it. Yeah, so I would like somebody to read section 125 for us before we come back to section 22. Section 125. Let me scroll there if possible. 25. Okay, Lakutu. Okay, I think, yes.
Okay.
Yes, you can read.
Yeah, yes.
125. Yes, please proceed. Read from your hard copy. Section 125. Anybody with the hard copy, you can read 125.
Oh. This will be answered. Yes, my lord. Publication of name of company. Subsection 1. A company shall A. Paint or affix and keep painted or affixed the name of the company on the outside of the registered office and of every office or place in which the business of the company is carried on in a conspicuous position in letters that are easily legible. B. Where the company has a common seal, have the name of the company engraved in legible characters on the seal. And C. Have the name of the company accurately mentioned in legible characters at the head of the business letter, invoices, receipts, notices, or any other publication of the company, and in the negotiable instruments or orders for money, goods, or services purporting to be signed or endorsed by or on behalf of the company.
Okay.
Should I continue?
Yes, continue to the end.
Yes, sir. Subsection 2. Where a company defaults in complying with subsection 1, the company and each officer of the company that is in default is liable to pay to the registrar an administrative penalty of 250 penalty units. 3. Where an officer of the company or a person purporting to act on behalf of the company uses or authorizes the use of a seal purporting to be a seal of the company on which the name is not engraved as required by subsection 1. That officer commits an offense and liable on summary conviction to a fine of not less than 125 penalty units and not more than 250 penalty units.
Right.
4. Where an officer of the company or any other person signs or endorses or authorizes the signing or endorsement on behalf of the company of a negotiable instrument or order for money, goods, or services in which the name of the company is not accurately mentioned in accordance with paragraph C of subsection 1, that officer or person is personally liable to discharge the obligation thereby incurred unless the obligation is duly discharged by the company or otherwise, but without limiting the rights of indemnity which that person may have against the company or any other person. 5. The use of the following abbreviations. A. LTD stands for limited. B. PLC stands for Public Limited Liability Company. C. LBG stands for Limited by Guarantee. D. PRUC stands for Private Unlimited Company. Or E. PUC stands for Public Unlimited Company. It's not a breach of this section.
Good. So section 125, which reenacts with modification section 121 of the repeal at 179, is telling us about the necessity to accurately publish the name of the company at the trading places or operating places of the company and on the various correspondences and also stationery of the company. And we are told that where care is not exercised and there's an inaccuracy in writing the name of the company or maybe documents involving some transactions, if the company, for example, decides not to honor it because the name is not properly captured, you, the officer who signed the document with respect to that transaction, which bears inaccurately the name of the company, will have to pay or will have to meet whatever expenses associated with that transaction. So let's go back to section 22, the reservation of a name. Yes, read for us. Well, it is possible if you are going to register a company or you have in mind to register a company, but let's suppose that you are not doing so immediately. It's permissible to apply and have your choice of name reserved for you. So make the application to the registrar and you pay the requisite fees. Your choice of name can be reserved for you. But the reservation is not supposed to go beyond 2 months. You can reserve a name for 2 months, meaning that for 2 months, there is some kind of like a freeze on that name. Nobody in the world, like as far as Ghana is concerned, nobody in Ghana is permitted to use that name. So you can get that done for 2 months. And after 2 months, you can again apply to have it for 2 months extended, so 4 months. But beyond that, the name will become available for everyone. So let us keep that in mind. And the reason for this reservation is that maybe there's a particular name you are interested in. Now, if you don't reserve it and somebody takes it, and at the time that you are ready, if you present it, you'll be caught with the rule that the name has been taken or the name is misleading or the name may bring about confusion. as it were. So you have to keep that in mind. Any question? We are supposed to discuss constitution of the company, but because of the fact that you have to go for another class, we'll end that here and we'll continue at our next class. But if you have like questions, we will take them.